So I met you this morning, no need to further introduce myself, but before I do this program in particular, I should add something to my bio. My husband's a pediatrician in Kerrville, Texas, a solo practitioner. My dad was a heme-oncologist, and my grandfather was an obstetrician in Omaha back in the 40s, carrying his little black bag. So I'm a third-generation physician family member. I always say I went to law school to see how much my family really liked me. But I mean no disrespect to physicians, certainly. But I just want to tell you that, yes, I am a lawyer, but I am related to some people you would really like. So I mean no disrespect in this. But it is, as Sherry said, it's a huge issue. And it's not that it's not that it hasn't been there. In any field, there are obviously very, very smart, good practitioners that are inappropriate personally. So it could happen. Believe it or not, there's even lawyers that are inappropriate. But for physicians, of course, it's a huge issue. So what I want to do with you in the time that we have is I want to talk to you about the legal implications of disruptive behavior. And one other thing, I have to tell you that Sherry is my good friend, and I completely browbeat her in the front row. And I'm actually going to do my 2 programs back to back because I have a plane to catch. So thank you, Sherry. I owe you. Okay, disruptive behavior. So let's talk about the problem. I'm confident that none of you have disruptive physicians at your hospitals, but there are people who do. There's tons of studies out there. They're constantly crossing my listservs of various different studies on how big a problem this is. This one actually goes back to 2011 AMA News, but I like this quote because it has some specific examples of what we probably would all agree is disruptive behavior. Shouting insults, discriminatory behavior, substance abuse, incompetence, physical assault, profanity, spreading of malicious rumors, throwing objects, and yelling. Although the incompetence, of course, falls into a whole nother kettle probably. But that is what you as physicians are reporting on your colleagues. As you'll see, the study said 70% of physicians polled said yes, they had seen disruptive behavior. But probably more disturbing, in that same study, they said that 77% of the people who responded, 850, said not only did they have personal concerns about that behavior at their facility, 99% said that it does affect patient care, that it's not just a private issue. 60% said that their organization had received at least one complaint from a family member or a patient, and I think that just points to the futility, feeling like this is not necessarily always addressed on an institutional level. 21% said they had seen such behavior actually contribute to an adverse clinical event. So we do know that disruptive behavior leads to bad communication between providers, physicians, nurses, people in the OR, whatever it is, and that bad communication then leads to patient injury. Now, there are so many of these lists. I don't know if you've seen them, so I don't mean this is not the certified list, but there's a lot of different ones. You may or may not agree with the priorities, but it's always the same players in different order. The one that's missing from this list, and I think this came from I should have a citation on this slide, but they're always the same players, except for the one that's missing on this particular list is hand surgeons. Hand surgeons always get a rap for being disruptive. How many hand surgeons could there be out there? But anyhow, the hand surgeons are usually one of the areas of medicine that tend to have disruptive behavior as well. Obviously, you can have disruptive physicians in any field, but these are the ones that seem to be complained about or have complaints most frequently. This is an excellent report. Again, it's a free report. You can pull it down here from ACPE. Excellent. It is physicians looking at the issues. So a lot of these poll results are coming from this report. I highly recommend this. It's not a very long report. It's very readable and very interesting. But in that report, you'll see this graph. Now, it's a little bit difficult. Just so you know, what they were asking respondents is how much are you worried about something? And then they were looking at how much that's an actual concern. So it's interesting, people were more worried about discriminatory behavior, physical assault, and substance abuse than were actually true. So the Much more frequently happening with less concern, the opposite was degrading comments, inappropriate jokes, and profanity. People were not as concerned about those, and probably because they have less safety issues, but they were happening more than the concern would have reflected. And dead on accurate. The amount of concern about incompetence and the amount of incompetence is pretty equal. By the way, two others that were really equal are refusing to follow protocols. The level of people being worried about that's pretty much how much it was happening, and inability to work with others. So it's just kind of interesting to see, but this all points to, of course, physicians are concerned about this, because it just reflects, in addition to all the patient safety and legal issues, it just reflects poorly on everyone. Sometimes we, and I say that we because it's the entire healthcare community, not just physicians, in some ways, sometimes we enable people who are just bad, who need to have their mothers talk to them. And we say things like, well, he's such a good doctor, or her patients really love her, or he has a surgical personality. I really like that one. She holds others to her own high standards. Yes, she's impossible, but at least that's what she expects of others. He's just burned out. You know, you hear this all the time, but at the end of the day, really what we're talking about is issues that are critically important to all of us and have big legal implications. So that's what I want to get to. But before I do that, I work with a lovely gentleman, Dean White. He's actually not he is a dentist who's gotten very much into, he was actually the head of medicine, the chief, what am I trying to say? The head of the medical staff for a hospital through dentistry, which is very unusual. Anyhow, to use Dean's example, which I like, if bad behavior gets good care for your patients, you're much more likely to do it the next time, right? So we reinforce bad behavior, and that is because nursing staff tend to respond, administration tends to respond, and so we do, of course, incite further bad behavior, but what I love about this definition is that at least it shows that maybe the bad behavior really is well intended, i.e. to get great care for my patients. Disruptive physicians usually do not see their behavior as inappropriate and will say that they're just trying to get the best care for their patients. They're usually excellent physicians with issues of obsessive behavior and control. Okay, but at the end of the day, again, it's a patient safety issue. Overwhelmingly, as a patient safety issue, and shows and presents serious and significant legal liabilities to you individually as well as to your facility. So let me break these legal liabilities into a couple of categories. Obviously, it has an implication for legal claims brought by patients, staff, and the physician we'll get to in a minute. The whole connection between disruptive behavior, angry behavior, and patient safety, that connection is made pretty clearly. Now, it's made in some studies, and there might be some questions of those studies, but where it is absolutely black and white clear, unfortunately, is in the lay press. This comes to you from the New York Times. This is an article that talks about, it says the equivalent of road rage, abusive behavior leads to preventable complications and even death. So I've seen this in USA, I've seen it in multiple newspapers, Time magazine, Newsweek magazine, they've all covered it. Now, when your patient is reading this material and hearing about it from Katie, Matt, Allen, everyone on the TV too, Oprah, etc., when they hear yelling equals I'm not safe, and now they're in your office, your ED, what am I saying? Of course, it's your ED, and they hear yelling, what's the first association they're going to make? I'm not safe here. That connection has been made over and over and over in the lay press. So if I'm lying there and I hear yelling or something said that's abusive, and I immediately assume I'm not safe, then if there's any untoward event or my outcome is not 100% ideal, what's the association? I wasn't at a good ED. Do you see that? I'm not saying it's truly cause and effect, but it sure is cause and effect in the world of the public, which becomes your plaintiffs. So again, I said this kind of when I was talking to you this morning, is that it's very important not only that you give excellence in care, but that you have excellence in pay as much as you can in the limited time you have and the stresses of an ED to establish a good physician-patient relationship, because that absolutely can be connected to the chances of them being able to listen to you explaining a result, especially if that result is not what everyone had hoped for. Here's the bottom line. Warm and fuzzy is great risk management. All right? The more you can make your patients feel comfortable, listened to, appreciated, all that, we all know, it's not only makes it more fun to go to work in the morning, but it overwhelmingly does help reduce the amount of claims against you. So we all know that anger, abusive behavior, whatever it is or how it's perceived by the public, they are much more likely to think that that is a bad doctor. That's pretty commonly in the materials that you read. The second one I often don't see, and it's very, very important, and that is legal claim, the legal liabilities you present with the staff. And I want to underline this because, again, I know many of you are in leadership positions. So if you have someone, they're the best physician, man, you can count on her, or man, you can count on him, but they have disruptive behavior, you got to be thinking liability, like how's that going to turn out to be a very expensive lawsuit from one of your staff members who's putting up with that abusive behavior. The two most likely, it's going to come under the rubric of sexual harassment or a hostile work environment. Those are the common names, and this is state by state to some extent what claims are brought up. But there's also federal law, of course, against sexual harassment and creating a hostile work environment. So let's say you have someone in your emergency department. It could be a nurse, it's a unit clerk, it's someone who has been subjected to repeated bad behavior and their complaints are not addressed and that issue is not resolved, and they decide to bring a claim against you. EEOC. Has anyone ever dealt with the EEOC? Well, it's kind of an embarrassing question to ask you, put your hand up. But if you have in your facility ever had an issue addressed by the EEOC, let me tell you what the legal standard is. I'm saying this facetiously. But with the EEOC, you're guilty until you're proven guilty. The EEOC is, of course, a very, very important organization, and it's there for very, very important reasons. But when you are dealing with the EEOC and you're on the other side, it is breathtaking how quickly how you're proving that you're not guilty. It's a difficult body to deal with. So let's say you're now in front of this claim. You've got a state claim, you've got a federal claim, whatever. And what's available to the person, the employee, who's saying that they've been subjected to this behavior? Well, they can get back pay. They have to rehire them if you fired them. Might be a promotion, reinstatement, front pay, reasonable accommodation. All of that can come up. Anything that's going to make that person whole. So in this context, of course, you didn't fire this person, but this person is saying that they were constantly subjected to this bad behavior. So we had to put some number, some financial number on what it's going to take to make them whole for that bad behavior. You also can have to wind up having to pay for their attorney's fees, expert witness fees, court costs, possibly compensatory or punitive damages. Mental anguish, again, could be considered as one of the elements of damages. And then the best part is then you have to cure the source. What that means is you still have to get rid of the doctor no everyone was too terrified to say anything to. So you've now gone through this incredibly difficult legal process, expensive legal process, bad press in town, etc. And then you're still going to have to go back to the beginning, which is dealing with this person in your ED that is truly a bad player, is truly not able to play with others. Now, I know I'm singing to the choir. We all know this. Why is it that anyone would keep someone in place that is so abusive? Right? This is the big fear. The number of physicians who are allowed to stay around with bad behavior, or actually they're not even, or competence issues, this comes in too, but the physicians that everyone knows should not be allowed to behave the way they are or shouldn't be allowed to do procedures, the biggest reason they are still in place is everyone is terrified of antitrust. Now, I don't want to, whoa, sorry. I don't want to minimize antitrust. Antitrust is a nightmare. It's very, very expensive. Again, I'm not suggesting you go there, but here's what I want to let you know, and that gets into the whole role of credentialing, and specifically the HCQIA. There are laws in place that will assist you if you have to deal with someone who needs to be removed. It is easier, HCQIA, because of my time, the Healthcare Quality and Improvement Act was actually signed by Dr. Reagan, President Reagan. So HCQIA, way back in the Reagan administration, was a law that was passed that was trying to make it easier to deny people credentials in the first place, i.e. the credentialing process, or to get rid of them through peer review if that became necessary. So, and it is specifically meant to protect you from antitrust actions. So here you have a bad player, peer review comes up, you need to get rid of them. Everyone's saying, oh, we can't do that, antitrust. Yes, you can. You just have to follow the rules that have been supplied through HCQIA. HCQIA is the only way you're going to prevent the lawsuit that the physician's going to try to bring against you. By the way, when I talk about antitrust, there's two different kinds of antitrust claims. You can have the claim from the individual, which is what HCQIA is meant to protect you from, and then you also can have the federal antitrust claims, and that's what, again, a lot of people get that confused too. But I don't have you for a semester of law, I have you for another 15 minutes. Okay, so HCQIA. And what HCQIA says is follow procedural rules. Give good process. Give due process to anyone who is being subjected to a concern about whether or not they are or are not a physician that you want to have on your team. So it's not going to prevent, again, all antitrust actions. It will prevent the suit against you if you follow the rules. Due process. So what does that mean? It means if you're going to have a review of a physician, you need to give them adequate notice. You have to give them enough information so they know what concerns are going to be raised at the table. You have to give them an opportunity to prepare a defense. You have to give them the opportunity to have a lawyer should they so choose. You have to have them, they have to be able to cross-examine witnesses. They have to have a written record. There has to be an appeal process. But there's a fairly long list about what constitutes due process, but your lawyer knows it, and you know it kind of as a gut check. You should have an an appropriate hearing body. It should not be people who are competitors. It should be other physicians sitting in the body who can do this work without having any competitive concerns in place. Again, discovery is very important. You have to allow full discovery of the physician, let them know what actually are the complaints against them, and I've said most of these. The best way to teach in my world, I think, is a story. So let me tell you a story about how not to do this very quickly. There's a story out of Dallas, and the story involved an invasive cardiologist. And this invasive cardiologist apparently was I don't know if he had been excluded from the other cardiologists or if he was self-excluded, but they were not getting along well. Something came up in the cardiac, there was a cardiac procedure, a cath. There were some questions about his performance in that day. And so the cath lab director immediately suspended his privileges, which, by the way, is dead on okay. Because if you have any safety concerns, you pull someone out immediately and say, we can't let you do any other procedures unless we know that you're safe, right? So far, they're fine. The problem is they had all the other, I don't think anyone did this on purpose, but this news was given to him by all the other invasive cardiologists in the hospital. They actually greeted him in the hall like a posse, remember this is Dallas, and said, you can't practice here anymore. These are his competitors. And oh, by the way, if you even talk to a lawyer, you're never, whatever. Sign here, don't get to talk to a lawyer, and on and on and on. Then they didn't tell him where the meeting was. They didn't tell him what cases are being were going to be reviewed. I mean, they could not have done it worse. You want to know what the reward was in court? I had to write it down so I'd remember. You want to know what the reward was? $366 million. $366 million. Now, the hospital went back to the appellate court and said, really? Really? So the appellate court said, okay, you're right, we'll reduce it to 22.5. This stays in the appellate court system for about 2 years, and finally, I believe it was only last year, and this started in 2004. So in 2011, 2012, finally the whole thing got thrown out. And the physician in charge, the physician in this case, he's never going to get a cent. That's probably great news. I just have to ask you, how much did it cost that hospital to be in court from 2004 to 2011 or 12? I can't even begin to imagine what was the cost the hospital to address this. So here's what you need to know about credentialing and peer review. Your lawyer is your friend. If they say dot that I, cross that T, what's important is not that you allow the bad players to stay. I feel like I should break out in song. The problem is not that you should get rid of bad players. You just have to do it exactly right. And that, again, due process, HCQIA, follow your lawyer's advice, be appropriate with your peer review. But at the end of the day, do not tolerate bad behavior. And again, hopefully it's not peer review. Hopefully it's credentialing. If you have good reason to believe that someone who's seeking privileges is not going to play well with others, don't let him in the first place. Again, follow the rules, avoid antitrust, and get these people out of your pool. And then last but not least, I'm sure you all know that there is a requirement from the Joint Commission that you have a code of conduct. You're supposed to have a code of conduct for your physicians in the hospital. That's a physician leadership issue on a hospital-wide basis, but it's certainly something that all the other physicians in the hospital should be aware of in your ED. It's certainly something that can be called to the attention of any physician who might be causing disruption with their behavior. Put them on notice. But again, this is a part of the Joint Commission requirement. Code of conducts and have it be specific rules on what will and will not be tolerated, so that you do have something to rely on should you ever be in that situation of trying to curtail or completely take away someone's ability to practice in your ED. And again, there's a lot of good resources on that. This medical economics article, 2011, very good about explaining the problem, what a code of conduct should look like. If you do not have one, or if you want to revise yours, I use that as a resource. And AMA has actually released a sample code of conduct that they feel is more physician-centric than a lot of the codes of conducts that came out of other part of the healthcare industry. But again, to my friend Dean White, I love this. Resist the temptation to treat special people special. Everyone's got to follow by the same rules, and that's going to be good for your patient care, patient safety, but also prevent really unnecessary legal liabilities in your ED. Thoughts, comments, questions? I'm going to go ahead and move on to a whole lot of alphabet soup.